Our next speaker is Dr. Olivia McGill. She's a licensed psychologist who currently serves as the Deputy Director of Health Services with the Harris County Juvenile Probation Department. She previously worked with a mental health court now called Court 360 and Girls Court. She has been working with adolescents for almost 20 years, started working in a grant-funded program in urban schools in St. Louis, Missouri, before moving to Texas, where she worked at the Al Price facility of TJJD. After leaving TJJD, she came to Harris County Juvenile Probation, worked for 7 years in the forensic department. Currently, she helps shape the process and procedures of the specialty courts, mental health programs, and the medical department here at the Juvenile Probation Department. Thank you, Dr. McGill.
You want that one?
Perfect. Yeah. All right. Thank you. Thank you. Thank you. Thank you. Thank you. Good afternoon. Good afternoon. You know, I have talked to less engaged groups than this, so your eating is not going to bother me one bit. So please proceed. I know that, first of all, I just am so impressed with how many of you guys have committed to being here Friday and a Saturday to learn more about the juvenile justice system. I know this is a sacrifice to your families and to your workload, and I'm in awe of how many are here. So I'm going to talk about the specialty courts. I know that you guys have had a number of speakers giving you tons of details. I do not plan on doing that. My intentions will be just to give you a global understanding of the specialty courts. You have the slides. You are all extremely educated. I will not bore you with just reading slide by slide. I just want to give you the theme of the specialty courts and then answer any questions that have been posed and try to get off the stage as quickly as possible so you guys are back on track and can get your Saturdays going. All right. So again, my name is Olivia McGill. I'm the Deputy for Health Services, but prior to that, or many moons ago, I was the psychologist that started the first specialty court that we had in the juvenile program, which was the mental health court, and then I also served as a psychologist for the girls court, which is now called the care court. So I'm speaking to you from an administrative position now, but I'm also speaking to you from having been on the ground level with the specialty courts in the beginning. Okay, so problem-solving courts. For those of you who may not be familiar, they came out of the adult system, and the concept was they realized that many individuals were coming, was like a revolving door through the criminal justice system where many of the issues were not being addressed, such as drugs, mental health. So an individual would go into jail, get medication, go back into the community, get back off of their meds, and kind of repeat the same cycle. And it was costing all of us tons and tons of cash in terms of just going through the same process over and over again. So what they decided to do was to look at seeing if they could address the underlying cause of some of the individual's criminal behavior. And it was quite effective. It held a great deal of accountability for the system to really meet the needs of that individual, got them, the individual, in a more stable environment so that they weren't using the criminal justice system for treatment. And then as a result, saving the county, state, whatever, tons of cash. So it was so effective in the adult system, they just started to try to apply this to the juvenile justice system. Some of the more issues that have been addressed globally that have been effective: substance abuse, domestic violence, mental health, and I will go ahead and talk to you guys about ours. So as I mentioned, it's to really improve the individual's functioning at all levels. And when we're talking about juveniles, then there's another added layer of family development, family cohesion, educational, health. These are all things that we are all trying to address. Specialty courts have a different approach, and they're considered non-adversarial, or that is our intention. I want to acknowledge I have in this room a number of people who've been around and working with the specialty courts, from judges to prosecutors to attorneys, and I would welcome any of their feedback and thoughts from their experience. But generally speaking, they're supposed to be non-adversarial. What does that mean? We try to do that in the way that it's approached, as the way that it looks. Judges who run specialty courts do not work from the bench with their robe. They sit at a table with all the other team members that are working collectively to really get this kid in the direction that he or she needs to go. The team is made up primarily of these individuals that are listed on the top screen. I'm going to talk globally, and then I can tell you the little unique differences with each of the courts. So obviously there's a judge, an attorney assigned to the case, a district attorney that sits in on all of the cases. A clinical psychologist is attached to each of the courts. Their role and responsibility is to understand the child's needs, both psychologically, health-wise, just a kind of a wraparound approach, and to create a treatment plan. A court case manager helps to kind of keep the flow of court going, setting dockets and such. Probation staff. I want to take a moment to talk to you what's different about the probation staff that work in the specialty courts. They have very small caseloads, 8 to 10 on average, and the expectation is that they would be working very intensely with the kid, being creative in the way that they're meeting the needs. There was a kid, for example, when I was in the mental health court, had been out of school for about 2 years. I think at that point he was 15, obviously a number of years behind school, and it had created a great deal of fear around school. Mom was in a domestic violent situation in the home, just was really trying to just keep the peace, and making her kid go to school was just not something that she felt like was worth the endeavor. So we would have the probation officers go to the house every day to bring the kid to school. Every morning, 7 a.m. Day one, when we showed up at 7 a.m., ready to try to get this kid to school, he was on the roof of his house, and he refused to come down. But that's okay. We'll come back day 2, and day 3, and day 4, and day 5. And we'll continue to work with a young person to really get them to the place that they need to be. The probation officers are expected to be flexible. We realized after about 4 days of conversations from the roof, this kid isn't going to go. So we got a situation where the mother, who was wanting to leave the abusive husband, but didn't, her main concern was financials. So we were able to get her and her son in a joint program in one same building where he could go to school and she could do some of the classes she needed for her advancement. And with that support, they were able to kind of continue their education and improve the functioning of their family. But that's not something that the probation department probation officer would do just on a regular case, right? It's a high level of involvement, high level of creativity, and that's the expectation of the probation officers. They are on call 24/7 and are expected to respond to the needs of the kid and the family. We often have all the service providers. I don't know if anyone has talked to you guys about the clinical services in the juvenile probation department. Has anyone talked about like multisystemic therapy and yesterday? Okay, perfect. So those type of providers are often attached to the courts as well as providers in the community. They will either come in person or present a report. Okay, so let me go through the 4 that we currently have and talk to you about the changes in a couple of them. SOAR is our drug court. It is run out of the 314th District Court. It began in 2010. The success rate is about 78%. So on each of the courts, I will tell you the completion rate, where kids were entered in the program and successfully completed. Mission statement, blah, blah, blah. The court team, as I mentioned to you, most of them have some of the same players. One difference in this one is they have an outreach worker, and the outreach worker is the individual who will help the kid get a job, get an ID, make sure that the mom has some of the social service needs met that she or the family may have. Target population, all of the target populations in age are about the same, 14 to 17. Obviously, this individual must have a substance abuse problem. The kids that we're trying to work with here need to have severe problems. One of the things that someone may have already kind of talked to you about is the switch in juvenile justice. Research continues to show that kids should get the least amount of intervention needed to get them out of the system. The deeper kids go into the juvenile justice system, the poorer outcomes that there are. So when we talk about a program where you are coming to visit the judge on a monthly basis, sitting around a table with a number of providers that know a lot about you, that's a deep level of intervention. This is for kids who really, really need it. That if otherwise these services were not given, they would likely end up in out-of-home placements. These kids are post-adjudicated, minimum of 9 months, moderate to high risk of delinquency. As it relates to the substance abuse, we're really looking for dependency diagnosis. No need to worry yourself with that, but the concept is we're just not talking about a kid who's using a little marijuana on the weekends, okay? Exclusionary criteria, you can just kind of look at that, but generally speaking, if whatever court you're working in, drug court, human trafficking court, the concept would be that there aren't a lot of underlying confounding factors. So, for example, in a drug court, we're not looking for a kid who's significantly involved in gangs. We're looking for kids where the primary problem is substance abuse, and if we can effectively address that, we hope to get them out of a juvenile justice system. Any questions so far? Yeah, oh, yes. Hello. The exclusionary list, quite a good question. So some of the exclusionary criteria for each of the courts are based on some on research, some on statutory regulations, and then some on clinical judgment. It is not. It is not. And that is one that we've actually been trying to work about getting off so that we can consider burglary of habitation offenses. Any others? Okay. Each of the kids has a level, and they come in once a month to meet with the judge regarding their treatment progress. We try to make sure that they are rewarded for their improvements, and if needed, sanctioned when there has been lack of progress. But our goal is to work more on the rewards and work on more of additional problem solving to address the issues that have not been successfully addressed. Again, a non-adversarial approach. In this court, the kids do generally come in once a month to meet with the judge and review their progress. The community providers are often sitting at the table and can provide information about their substance abuse treatment in community providers. When we can, we try to connect youth with kids in the community, with providers in the community, so that when they have finished dealing with the juvenile probation department, they don't need to change providers. They've already established a relationship that can continue. GRIP Gang Court. So this is currently out of the 313th. Did I say Judge Oaks earlier? Oh, yes, hello, Judge Oaks. One of the things that our mission statement, blah, 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 same individuals are participating at the table with Judge Oaks. Target population, very similar. Obviously, history of gang involvement. This one is a bit different now. In the juvenile justice attempt to make sure that we are addressing the needs of the most vulnerable youth, the GRIP court is now receiving referrals only from our gang unit. So as attorneys, you would not be able to recommend participation in the GRIP court as of now. Kids who have struggled on the gang unit, meaning they're in the community on a special probation, out of that unit that are not doing well are then recommended for participation in the GRIP program. Similar exclusionary criterias, looking for youth who've got the intellectual capabilities to participate, and youth and the family willing to participate. The specialty courts are considered voluntary. I am more interested in the voluntariness of the parent than I am of the child. The parent's commitment to bringing the kid once a month is quite a commitment. Having individuals in your home on a regular basis, quite a commitment. Kids sometimes need some encouragement to want to participate in these type of things, but we're really looking for parents who are willing to go the extra mile to get their kids to the services that they need. Success of the GRIP court in recent times yields a 83% success rate. Lately, we've been doing quite well with our females, 100% success rate. Of course, that's only with a very small number of females, and an 80% success rate with our males. We're continuing to evaluate the program so that we're meeting the needs of the kids, so that we're maximizing our success rate. Care Court. Care Court is out of the 315th. Judge Shapiro is the presiding judge of the Care Court. Care Court, for those of you who've been around, has been recently renamed. This was formerly Girls Court. The creation of this court was to address the number of domestic teen sex trafficking victims that Houston has. In more recent times, we realized that there are males that are also victim of sex trafficking. So to be more inclusive, the name has recently changed to Care Court. Just in 2017 alone, the Juvenile Probation Department has identified over 100 youth that are either reporting or highly suspected to be involved in sex trafficking. Give me just one little 2-minute privilege of talking to you a little bit about human trafficking. It's kind of a newer thing, and I want to make sure that people are aware that it's pretty prominent in Houston. So for children to be sex trafficking victims, there does not need to be any coercion proven. It is just that the child is involved in the sex trade and is under the age of 18. Definition, just to give you just a couple stats, I don't want to bore you, but 1 in 3 runaway teens will be lured within the first 48 hours. So whenever you're dealing with kids that have a significant runaway history, it begs the question to ask them, what are you doing for shelter while you're out there? How are you eating while you are out there? Many of these kids are approached quite quickly with promises of protection and food and a really, really good time, but quite quickly that really good time turns into them working. The estimated number of men that female victims usually are having sex with is 1 to 15 each day. I didn't put it on the slide, but the average age of entry is 12. So Houston has really been identified as a hub for this. So the Juvenile Probation Department has been doing a better job of asking questions to elicit. These kids are not ones that usually say that they have been victims. In many instances, they do not feel they are victims at all. They feel like they've willingly gone into this. They feel like they're in a great relationship with this guy. And it just takes some probing on our part and hopefully on your part to uncover those who may be involved in the sex trafficking industry. Mission statement. Court features are very similar to the other two that I've just talked to you about. Similarly, these are all post-adjudicated kids. This court is for those who are at risk and active involvement in sex trafficking. However, most of the participants are actually actively involved. About 90% of them have a history of trauma, whether the trauma preceded the actual sex trafficking or the trauma occurred while trafficking. It's often very common that many of these young persons are on drugs just to get through the night and to work that much. So there's often co-occurring substance abuse problems and untreated mental health illnesses. The care court has about an 80% successful completion rate. This is a difficult population to deal with. As I mentioned, many of them do not identify themselves as victims and are very attached to their pimps and will often immediately return to those pimps upon release if significant intervention is not done. Many of these young people were in neglectful situations, so they are often not cared for in the way, and the accountability in the home is not often there for these kids to successfully thrive. And treatment for these individuals can really take a long time. Lastly, Court 360. This is out of the 315 District Court with Associate Judge Dina Fisher leading it. This is our newest evolution. This was formerly the mental health court that started in 2009. As I mentioned to you earlier, this was one of the first courts that was created. Court 360 is looking to work with youth that have more significant mental health problems than the previous mental health court had. It is the same concept of really doing wraparound services with the families, but we're looking for kids who don't just have conduct disorder, don't just have behavioral problems, don't just have substance abuse problems, but significant mental health difficulties. Some of the more common diagnoses that you will see would be a mood disorder, bipolar, post-traumatic stress disorder. These are some of the common ones that are going to be currently served in the Court 360. Our goal in all of these courts is to make sure that the families are connected to the services so that once we are out, they are able to continue treatment. It is not the expectation that these kids, after being involved with us for 6 to 9 months in these programs, will come out as healed individuals. Many of these traumas and problems will continue and follow these kids for a very long time, but our hope is through this court, we can get them out of the juvenile justice system, connected to services that can keep them going in the direction of success for years to come. I put the contact information for the administrator of the specialty courts. If you have additional questions, he would be a good resource to ask. In terms of referrals for attorneys, as I mentioned to you, the GRIP court, which is the gang court, currently isn't taking referrals outside of our own system, but the other 3 courts, particularly Court 360, have a referral sheet that if you feel like your young person is a victim or needing the treatment of one of these specialty courts, that you can go to the court rep and indicate your interest in having this young person evaluated for participation. Many of these courts have designated attorneys attached to the courts, so this would be in many situations you releasing the case to the attorney that's assigned to the court. Any questions? Yes.
For the sex trafficking victims, it's been my experience in the adult court that sometimes the prosecution may forcibly hold onto the victims in order to get them to testify against their pimps. Or at the very least wait for the trial phase to be over before releasing them. I don't know if that's necessarily the case with juveniles, but is that something that happens to these sex trafficking victims? Are they counseled to testify against the pimps?
Yes, and in many instances especially we have kids who have, during the time of treatment, there are court cases coming up. We definitely have psychological counseling for those kids as they are going through that process. The probation officer and the likes would go with the child for testifying. Truthfully, this is not something that the juvenile justice system is pushing on our kids to do. We really allow the adult system to come over and really try to talk to the kid about their participation. We try to honor the decision that the young person is making in regards to that. More so, we are trying to keep these kids in the community as much as possible, so we are not doing these type of things where we're holding them hostage in a place to try to convince them, hey, if you testify, you'll get out of here.
So grip is not a condition of the disposition phase, right?
Correct.
Okay. But seeing that it's supposedly not adversarial, do y'all ensure that if the attorney for the child can't be there, that the child does not have discussions with the other side, the judge?
Yes, so there is. So I will say that the attorneys that are working in the specialty courts are a very dedicated bunch and are typically there, but in the instances in which they cannot, they make sure that one of their colleagues is there to represent the interests of the youth at each review hearing, which is usually monthly.
Is there a clearinghouse for this information, Doc, on where we can go to find out what courts are available, what their pre-adjudication, post-adjudication, as the names change, who to call to get referrals to the court with exclusionary information? Is there?
That's a great idea. No, we do not. But we can work on that. We can work on that. We are working on our website to be far more inclusive of information so that as changes happen, I know there's staff changes and things like that. We can be, we'll definitely work on that. Great question. So the district attorney has to agree to the involvement of that case. And so it isn't, while there are some offenses, let's say murder, obviously are very easy, some of the other ones, as you can imagine, are very case by case in reading the details of the offense. So that is really up to the district attorney to decide that he or she is willing to include that case into the court. Judge Fee. Would you say, what percentage would you say of cases that you represented, they actually ended up testifying? Has that happened much? Okay. Okay. Anyone else? Judge Newhouse, you want to add anything about? No?
Oh, I
All right. Well, thank you guys very much for your time.
Our next speaker is Terry Cody. Ms. Cody is currently a managing attorney with Catholic Charities of Galveston, Houston, Cabrini Center for Immigrant Legal Services, working with the unaccompanied minor and family immigration programs. She's specialized in immigration and nationality law since 1999. She was admitted to the State Bar of Texas in 1996 and is admitted to the Southern District of Texas Federal District Courts. Ms. Cody is certified in immigration and nationality law by the Texas Board of Legal Specialization. She's past chair and executive committee member of the American Immigration Lawyers Texas chapter for Texas, New Mexico, and Oklahoma, and the U.S.-Mexico Bar Association Board. Ms. Cody has also served as AILA liaison to the Texas Service Center and the U.S. Customs and Border Protection Houston headquarters. Ms. Cody is currently board vice president for SIRE, a therapeutic horsemanship organization. Please welcome Ms. Cody.
I hit the wrong button.
There we go.
Let's see, to the right.
There you go. Good.
All right. Thank you. All right, good afternoon. It's a pleasure to be here. I first of all want to thank Steve Halpert and the bar for inviting me. I want to, if I could, take a moment just to tell you what we do at Catholic Charities, the St. Francis Cabrini Immigrant Legal Services Center. It will kind of help inform why I'm here today. So what we do is we are legal service provider, nonprofit. We have a number of different areas that we provide services, including family visa program, where we do low-cost immigration services for families. And we provide services for criminal victims, victims of crime, I should say. And so there are a different number of visas available for victims of crime, a U visa, persons who've been trafficked, a T visa, and VAWA, Violence Against Women Act. So there's a number of types of relief that persons can come to that program for. We also have the a general citizenship program and different immigration general services that we provide for refugees and asylees. And then probably our biggest program right now anyway is the unaccompanied minor program. And what we do is we provide relief or we provide services such as Know Your Rights presentations, initial screening for kids who have been brought, they come to the United States. And they can be held no more than 72 hours by ICE if they are a minor that's unaccompanied. And then they come into ORR, Office of Refugee Resettlement custody, and they're placed in shelters. There are, I think, 8, almost 9 shelters in Houston area, the greater Houston area right now. And so we are working with 5 of those shelters. And so every kid that comes in has a Know Your Rights presentation in their language, whatever that may be. And then we have the screening. And then we will also provide representation for kids who are going to be released into the Houston area with a sponsor or long-term foster care, and that they have some type of immigration relief that's possible. When they're in custody, they're all already they've already got a notice to appear before an immigration judge, so they're in proceedings. And so, what we work, so we have a very high volume in that particular program right now. And so we do work with a lot of juveniles who end up coming into contact with the juvenile justice system. And so that's sort of an overlap with sort of what we do and what y'all do. I do want to make a quick plug. We are hiring. If anybody is at all interested or knows somebody who's interested, we are hiring for attorneys and legal assistants. We actually have pro bono coordinator attorney positions, so pass the word around. And we do work with mostly kids who are coming from the Northern Triangle, so it's Honduras, Guatemala, and El Salvador. We have a few kids who are coming from, and then also Mexico, and then a few kids who come from Bangladesh or India, Pakistan. So that's sort of the profile of who we work with and what we do. So yeah, we would be thrilled to see anybody who has a background in juvenile justice. Actually, there's an absolute connection between those two. So pass the word around. So anyway, so to jump off into actually talking about immigration consequences of criminal violations. Oh, there we go. Probably a good place to start is that talking about in 2010, the Supreme Court held that criminal defense attorneys are obligated to advise about immigration consequences with regard to their options in terms of plea deals as well as sentencing and convictions. this has had, I think, a tremendous impact on the criminal defense bar because this is not an easy area to be knowledgeable about what the implications are, because it is ridiculously complex. I think of it as sort of a multi-level whack-a-mole game, the vicious one, where, you know, the minute you think you've got one thing figured out, something else pops up that's like, whoa, where did that come from? It's really, and it's constantly changing. The AG, will suddenly decide to write an opinion to himself that is now changed the reality of asylum applications for people who are victims of domestic violence, per se. A Matter of AB came out, that was out of nowhere, and suddenly everything that we were doing, you have to take, a left turn and look for a different way to approach it. So it's a very complex area, and so it's an area that is very important to be aware of, but it's also incredibly difficult. It's arguable that the juvenile defense bar really shouldn't be subject to Padilla because the convictions that are in juvenile justice are not considered crimes. And we'll talk about whether it's actually a sentence for purposes of immigration. But there is impact of any sort of proceeding or finding in a juvenile justice system for immigrants, for immigrant minors. So it is still very, very important and crucial to your clients that you have some awareness of what the options or what the consequences are. Okay, oops. All right, so starting with the riddle. When can a juvenile non-citizen with a delinquency sentence be found deportable from the United States and admissible as a permanent resident to the United States? Does anybody here that has practiced immigration has some sort of intersection? So this sounds like absolute gobbledygook, I'm sure, because these words have very little meaning in reality. They are all sort of constructs of the immigration system. But if you want to just take a second and look at the riddle and identify the things that you think will be important to look at and define and evaluate as we go forward, so that you, hopefully when I finish today, and it's a very brief another 15 minutes to do so, you have a framework to look at the issues and to know what questions to ask and the resources to find out what the actual impact might be. Okay? So feel free to stop me and ask questions as we go forward. Okay. So there's a lot of ways that violations have an impact on status. There's criminal grounds of inadmissibility. There are criminal grounds of deportability. Those are sort of the two that people identify most often and most quickly. So if somebody's inadmissible, what does that mean and why is that important? Grounds of inadmissibility mean that the person does not have a current status in the United States and that they are applying to be admitted. That can include applying for a green card. Even if you're in the United States, you're still seeking admission when you apply for a green card. And there are certain basic concepts that are very important for this ground of admissibility that sort of overlap with criminal matters. It's good moral character is often a requirement. And also, there's certain areas that are unique to the inadmissibility grounds, which is doesn't apply to deportability, which can be for relief for abused spouses, and there's the crimes of moral turpitude are applied differently and for the two different grounds. Deportability applies when a person is not a citizen of the United States. They have some sort of immigration status, but they are subject to deportation. So they could be a lawful permanent resident, a refugee, asylee. And then there are also persons who are non-immigrants, that they're here in a status, they're allowed to be here. They've already been admitted, but they are deportable. Okay. Criminal violations also bar specific forms of relief, and they also could bar the availability of certain types of waivers. So, for instance, naturalization. I have a client who, as a young person, was convicted of attempted. It was fairly significant. It was assault, attempt to murder. I can't remember. The person didn't die, but it was a bad conviction, and he ultimately got the green card, but he was barred from applying for citizenship, right? Because they basically, no matter how long it is from the conviction, the person, they get to evaluate whether or not they think that crime that happened 200 years ago has an impact on their good moral character. So even if the person is admissible and you seek the relief to get them status change, but then ultimately they may not be able to apply for citizenship. So it has lots of impact, and these are just certain examples of things that are impacted by criminal. Yeah.
So this last line, even if they are not, even if a citizen or a national is not deported, based upon committing different offenses, they can be refused to sponsor someone new?
That's correct. Yeah, that's something that's relatively new. But yeah, it's the Walsh-Adams Act. And so basically, if somebody has convicted certain types of crimes, they are not able to sponsor other relatives or a spouse. Mm-hmm. Yeah. Yeah. We don't see it very often, but it is possible. I think it came out of the mail order bribe problem, where you find that somebody with these criminal backgrounds sponsoring somebody coming in as a fiance or a spouse, and then subsequently they get abused, and they had no knowledge beforehand. And so I think that's where it started. But yeah, that is sort of the genesis.
I've done some sponsorship cases, but I didn't know that because I hadn't done it in a long time.
Yeah, that's the case. Mm-hmm. Okay. All right. So as we said, that did I go backwards? No, we're good. So the persons that are subject to inadmissibility, it includes people who enter without inspection, applicants for admission. As we said, the first time somebody comes in, maybe they have a visa to have a green card, but they haven't entered yet. They're still subject to grounds of inadmissibility. Applicants for adjustment of status, people who are paroled into the United States. And so that is, a parole is when they haven't actually admitted the person. They just said, you get to come to the U.S. Almost as you're not really here. It's a construct that they aren't really admitted, but they're paroled into the U.S. for a certain purpose, testify in court, to do something, some other type of process. There's humanitarian paroles. So we'll let you come in for a little bit, but you really haven't been admitted. You're sort of a non-status situation. And then, of course, there are non-citizens. The non-citizens who are under the grounds of deportability, as we said, non-immigrant visa holders, non-immigrants that came in without a visa from a visa waiver country, refugees, lawful permanent residents, conditional residents. Okay, so I'm not going to talk about all of the grounds of inadmissibility, given that we have just a few minutes, but I have listed them, and so in the section that they're found under is listed in the PowerPoint and in the materials that came in the Dropbox. We can make the PowerPoint available also later. So crime of moral turpitude is one that does apply to, this is under inadmissibility. It also is a ground of deportability. And so it is one that there's a lot of focus. They're applied in different ways. For one, it's applied differently under inadmissibility than it is in deportability. So inadmissibility, crime of moral turpitude, except only one crime before the age of 18 and more than 5 years before the application of admission. And there's a term of imprisonment that may be imposed not more than 1 year, and the actual sentence does not exceed 6 months. There is so much depth when you have to look at when you're looking at whether it's a crime of moral turpitude. There's whether or not it's an intent crime that it has to be an intent-based crime to be a crime of moral turpitude. And so whether the statute has an intent facet, whether or not it is under a statute that is divisible, so you don't know whether the person had a malintent because the statute has two different possible crimes in the one statute. So it's not going to be a crime of moral turpitude if it's possible that the crime was not one of malintent. For instance, I think there's some burglary statutes, and I can't tell you which ones, but that would have that the person could have committed the crime without the intent to permanently separate the person from their property. And so that's, I guess, one example. Trying to think of another one. If battering a spouse is something that part of the offense is just a touching that is unwanted, that is not necessarily a malintent. So that may not be a crime of moral turpitude. So it's complex. So when you're looking at that issue, that is something that is, you'll find you'll spend a lot of time looking at the different aspects of crimes involving moral turpitude. Controlled substances are definitely a ground of inadmissibility under both the, ground of inadmissibility and a ground of deportability. And that is one that is particularly strict under both of them. But that said, there are some grounds, there is some instances where a conviction is required, and then others where not even a conviction is necessary, just admitting the fact that you had utilized or had possession of a controlled substance and have admitted it to an officer is enough. And they consider the physician who does the screenings for immigrants who are applying for green cards to be an officer. So that can be applied in areas where you don't even have a conviction at all. But in this ground of inadmissibility, the conviction is part of the ground for the criminal ground of inadmissibility. So anyway, so we go through. You could see that there's two or more offenses that have an aggregate confinement of more than 10 years. Traffickers, again, that just is somebody who has knowingly gained financial benefit, and so reason to believe that somebody has trafficked can apply. It doesn't need a conviction. Persons coming to the U.S. to engage in prostitution, whether it's the either side of it, the client or the non-client, the person engaging in prostitution. Somebody who's committed a serious criminal offense for which immunity was then claimed and departed. It's ongoing. There's human trafficking, money laundering. These are just criminal grounds. Now we're looking, then that's the criminal grounds of inadmissibility. There are other grounds of inadmissibility that are not criminal. That was really well done. All right. And deportability. So again, you'll see we have crimes of moral turpitude committed within 5 years of admission, 10 years if the person's a permanent resident, and sentenced to 1 year or longer, maybe and a sentence of 1 year or longer may be imposed. Convicted of 2 or more crimes of moral turpitude after admission, aggravated felony at any one time after admission. And so, the list goes on. A drug abuser or addict at any time after admission to the United States. And there should be a separate line there, but it's convicted of any firearm or destructive device law after admission. And then also there's the suite of espionage, sabotage, treason, and sedition. And then domestic violence. This is one that you didn't see domestic violence as a ground of inadmissibility. It's a ground of deportability. But this is domestic violence does not require a conviction. So this is one that reason to know that the person has ever committed it is also applicable for this ground. Okay, and then human trafficking offenses, also grounds of deportability. So obviously it's important to know what immigration considers a conviction, and it does differ from state code. So the term conviction means an alien with the formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where a judge or jury has found the alien guilty, the alien entered a plea, or nolo contendere, and has admitted sufficient facts to warrant the finding. Or also if the judge has, and the judge has ordered some form of punishment, penalty, or restraint. So deferred adjudication in Texas is a conviction. Diversion programs that require a plea or admission on the record are convictions. And there's reference to the cases that look at that. A juvenile court disposition is not a conviction for immigration purposes. So that's something that is extremely helpful with, when you get young kids getting into trouble. Also, the disposition under a plea diversion statute is not a conviction. So it's where there is no plea, where there is not a conviction. Vacated convictions are not. So there's a long line of cases evaluating whether or not a conviction was vacated because of a legal defect versus there's a different reason. Then that is what differentiates whether that is still going to be considered a conviction for immigration purposes or not. All right. Sentence. That is also obviously important. The period of incarceration or confinement ordered by court of law, regardless if suspended, is a sentence. So straight probation in Texas results in prison time. Suspended, that counts as a sentence. On the other hand, term of probation on deferred is not a sentence, as there's no period of confinement contemplated. So obviously if you're looking at a situation where a kid is being convicted and is as an adult, these are extremely important details to be aware of. And also, the focus is on the maximum potential sentence. 5. Okay. And so, you have to look at, of course, You guys are very familiar with this, I know, but you have to look at what the potential sentence is. The categorical approach, I mentioned earlier that when you look at the statute that the person is being convicted under, you have to look at different factors to determine whether or not it fits under an aggravated felony, or is it a crime of moral turpitude. There are seminars that last an entire day just on the categorical approach alone. Suffice it to say today that it is an area to look at when you have somebody where you have to determine whether or not the crime fits under one of those grounds of inadmissibility or deportability. Juvenile delinquency, the things I think that are really important, as we said, the things that are important to keep in mind. Why is it important to think about these consequences if a juvenile delinquency finding is not conviction? Well, one reason is that a lot of the grounds of inadmissibility that bar legal status and deportability do not need a conviction. The reason to believe that the acts have been committed can result in the ground of inadmissibility, deportability, or ineligibility for grounds of relief or waivers. Also, gang affiliation or allegations, even if there's no conviction, all it takes is anything where there's been any finding whatsoever or sometimes it's as much as an accusation of gang affiliation, and that will have a negative impact on the person's ability to ever become a permanent resident, and also every other phase of admission or deportation that they're considered for. So that's a big deal. We have one of our Oh, I apologize. It's my lack of knowledge. You said juvenile delinquency versus...
Juvenile adjudication, and then it's a delinquency adjudication. One has immigration problems, and the other one doesn't.
No. So delinquency, my understanding is under the guise of the juvenile justice system. And so if it's a juvenile delinquency, which I guess is like skipping school, or it can have an impact as far as if it's something where they have admitted, where there's a record, where there's an admission, there's proof of reason to believe that this person has done whatever it is that applies. So whether it's delinquency, adjudication, juvenile delinquency, if they're under the civil system for those, it is not a conviction. Yeah.
Ma'am, are those terms, juvenile adjudication and delinquency adjudication, are they defined in a federal statute somewhere?
No. This is just really probably a poor choice of terminology when creating the PowerPoint, to be honest with you. Yeah. I mean, I know there is a difference between delinquency and juvenile delinquency adjudication, but there's not an immigration definition of those two that is being differentiated. So, yeah. Thank you for asking that question. Yeah. Sorry for that confusing point there. Okay, I think I'm about out of time. So this is just a chart for reference. These are admitted to or findings of different areas that, this if you admitted to or there are findings of these particular criminal activities. Then on the other side, it shows whether it affects admissibility or deportability. So just for your reference. Okay, answer to the riddle. The riddle was, how could somebody be a non-citizen who is both deportable and admissible and they were in juvenile proceedings? Did anybody come up with any alternatives based on, yeah. So basically, what we're looking for is somebody who was did not have status, that there was, they were subject to deportation. I'm sorry, they did have status, right? Because they'd be subject to a non-immigrant who was admitted to the United States. They overstayed, so then they were no longer in proper status. They got a juvenile disposition that was domestic violence, and so they became deportable. However, they weren't inadmissible because they were able to apply for adjustment of status, because that was not a ground of inadmissibility. And so that is a real case, that I had somebody who was deported, ordered deported, and then in the same proceeding, we were able to apply for a green card, showing that he was eligible for a waiver of the good moral character issue. So, all right. Thank you, guys.
Our next speaker is Katya Dow. Ms. Dow is the Legal Program Director for the Juvenile and Capital Advocacy Project, known as JCAP, based at the University of Houston Law Center, where she is also a professor of practice. Since creating a juvenile record sealing clinic at the Law Center in June of 2015, Professor Dow and her students have sealed over 450 juvenile records in Harris County. Professor Dow also teaches an adult records expungement program, and in collaboration with Judge Dina Fisher has developed and co-teaches a juvenile representation program for dual status youth. Dow holds a BA in psychology with honors from the University of Texas at Austin and a JD from the University of Houston Law Center, where she was the editor on the Houston Journal of International Law. Ms. Dow previously practiced international commercial and insurance litigation in New York and Houston. Please welcome Katya Dow.
So I'm going to try to make record sealing as exciting as possible. I know y'all have been sitting for a long time, and for me it actually is a passion, but I know for a lot of people it is something that is not necessarily the most interesting subject, but I think I can make it interesting. So JCAP started a record sealing program in May of 2015, and since that time we've sealed about 500 juvenile records. Almost, not quite, but very close to it. We have a 99% success rate in sealing all requested records, and that actually changes because we have just recently been able to seal a few cases where we were initially denied and asked to wait, and so we've just recently been able to seal those. But it's around 99% now. And we conduct an annual audit so that we can research any issues with the agencies to ensure that all of the agencies have complied as they're supposed to. When I began this program, my assumption was, like many people, that juvenile records are automatically sealed or it happens at a certain age. And mostly because it was everybody sort of thinks, well, these are juvenile offenses, everybody should be able to move on and not be affected by them anymore. Yesterday, people were talking, I just added this to my slides because I thought this was so good. Many people spoke yesterday about Section 5101, the purpose and interpretation of what a juvenile court a case is supposed to do. And one of the purposes that are listed, and which is referred to in several cases that were mentioned yesterday, is to remove the taint of criminality from children committing certain unlawful acts wherever possible. The reality is, when it comes to records, is that many individuals are currently being burdened by the taint of criminality for years and years, and it never goes away until the records are sealed. We're going to have somebody talking about collateral consequences, so I'm going to very briefly talk about them with regard to having a juvenile record, and specifically about cases that we've worked on that really demonstrate that. Regardless of whether the child's conduct was adjudicated, the child has a juvenile record with the Department of Public Safety and the Federal Bureau of Investigation, and that is a permanent record unless it is sealed. Individuals must report these offenses when asked about criminal history on employment applications or any other applications, school applications, where criminal history is asked for. So this becomes a barrier in many different ways, most importantly to education. Recently, the Common App, which is what is used in 90% of the country for children or teenagers to apply to colleges, has banned asking about criminal records. However, each college still can ask that question. And my son, who is 18 years old and just got into NYU, he went through this process, and 60 to 70% of these colleges do still ask about criminal and juvenile history. Often youth that have juvenile records will delay applying college or just not do it at all because they don't want to have to divulge that information on applications. And we have had many, many parents and kids come to us absolutely just panicked because they have to, they're getting to the point where their kids are needing to apply to college and they have a juvenile offense, and they know that they're going to have to put it on their application, and it's just very heartbreaking because right now we're not able to seal juvenile records until a certain age, which is what I'm about to go into. But once they are sealed, the individuals do not have to talk about that at all on any kind of application after that. So the other thing is that it's a requirement for law enforcement to inform the school and school district where an offense occurred when it occurs. I think within 48 hours is the rule. And because of this, that then creates a disciplinary record at the school, and that can be referred to and shared with colleges as well. So part of the sealing process requires that you actually send a copy of the order to any school district or school that was connected to this offense to make sure that that record is sealed as well. Employment barriers. 53% of employers in the U.S. ask candidates about criminal and juvenile records on employment applications, despite EEOC guidelines. Most of our cases where employment has been denied that we know of because they actually informed the applicant why they were being denied. Police departments, we have many, many people coming out of criminal justice programs that actually have minor juvenile offenses in their history. They are not going to be employed. Police departments cannot hire anybody that has a record. Home health care and employment working with youth, those are our main areas where people are coming from. And again, it's an application deterrent. We had a recent case that we sealed where, yes. Oh, no. Yes. So, for example, if any school, so if there's a kid that's involved in some sort of juvenile offense, then that offense has to be reported to the school where that youth came from. HPD has that requirement too. Yes. Yes. Yeah. Yeah. So we had a recent case where we sealed a sexual assault. It was a deferred adjudication. A young man had a relationship. He was 16. He had a relationship with a 13-year-old. He thought she was 16. That's what she told him, according to him. And then as soon as he found out that she was 13, he stopped the relationship. But then she was pregnant by somebody else. They did a DNA test. But her parents took action against him because they didn't know before they did the DNA test that it was not him. And so he ended up with a sexual offense on his record and has been, now he's older, but he's been waiting and waiting to do anything because he does not want to have to say that he's a sexual offender on any of these job or school applications. So it kept him from doing anything proactively with his life until we were able to seal that record. Public housing. A juvenile adjudication may foreclose an entire family from seeking public housing. Following the passage of the National Affordable Housing Act, the United States Supreme Court upheld public housing authorities' abilities to evict residents based on the offenses of their relatives, and public housing authorities are permitted to consider juvenile adjudications in determining whether families are eligible. Obviously, law enforcement, juvenile records are accessible by law enforcement, so adults with juvenile records may be treated more harshly. And obviously, the DAs have access to the juvenile records. So if you have somebody like we have had in the past, one of our dual status youth, where they have juvenile offenses and they haven't been sealed yet, and then they pick up an adult offense, that's the first thing you see when you open up the file is the list of juvenile offenses that they also have. Military. So we have a lot of military recruits coming to us to get their records sealed because many branches, well, actually all of the branches of the Army, you do first have to disclose to them that you have an offense because when you seal a record, even if you're going to seal it, you still have to divulge it to the military because even though the Texas Crime Information Center, or DPS, sends a notice of sealing to the FBI, and the FBI will do something to seal that record, there's still something left over that says there was a record that has been sealed. So that can be discovered, and if somebody lies as a military recruit to the military, they're going to take that very seriously. So we always advise our clients to tell their military recruiters that they have an offense, but they're in the process of getting it sealed. And we have been sent many people who the Army has said, okay, fine, thanks for telling us, now please seal this record. So the Army does require that you to seal it, but even though they want to know about it first. Youth and foster care. So since we do work with dual status youth, we have seen that this offenses have devastating effects on kids who are in foster care. So we have a lot of kids who have picked up offenses, as many of these youth do in foster care, especially if they're dual status and they've been in the system for a long time. And then they can't get good placements because, especially if they have some type of assault or violent offense, they can't find anything but the worst RTCs to be placed in. And we have and especially when they start transitioning out, we're trying to find transitional living for them as they are aging out of the system. It's almost impossible to find places that will take them if they have a criminal history. 70% of our sealing referrals come from youth who have been negatively affected by having a juvenile record. There's another program that does sealing of records through the HBA, and they primarily take cases right as juveniles are coming out of the system. And our cases, actually, most of them come from people who have had negative consequences. So we've seen so many different ways that people can be affected long-term into their adulthood by having a juvenile record. So the most recent sealing legislation, since I started doing this in 2015, the law has changed twice, and the legislature has tried, it seems over and over again, to address this issue systematically or systemically, which I think is a great idea. But unfortunately, it's not always, it hasn't always worked with regard to what they've tried to do. So one good thing that they did recently was they restricted access to these records they narrowed it to a bunch of, to fewer agencies that have access. However, the problem is that there are still consultants of the court that are allowed to have access to these records, which isn't defined. Anybody with a legitimate interest also is in the universe of agencies or people who can get access to these records, and is not limited. And additionally, all of these agencies that hold these records, the arresting agency, the probation department, schools and school districts, they also still have these records. Another thing that the legislature tried to do was provide sealing without an application or an automatic sealing process, which everybody thinks, well, why can't we just do that? Everything is digital now. Why isn't that possible? Well, unfortunately, it's actually not an easy process to do. It requires a number of maneuvers by a number of different agencies, all of which require additional manpower. And because this legislation was unfunded, you have all of these different agencies not being able to do this work that they're supposed to be doing under the legislation, especially in large counties like Harris County. Who is eligible? Somebody, it starts when you're 19 years old is when you're supposed to be able to get your records sealed without an application. And if it was not adjudicated or was adjudicated for a misdemeanor, so that means no felonies, can be automatically sealed. There are no pending delinquency matters, and not convicted of an adult felony or misdemeanor punishable by confinement in jail, and no pending adult charges for a felony or confinement, a misdemeanor punishable by confinement. So this is how this is supposed to work. The eligible person turns 19. DPS then they look at all, systematically look at all records of a 19-year-old and see if there was a juvenile offense. And then they send back, if it comes up and it's flagged, they send it back to the probation department of the county where it originated. And then that probation department is supposed to make sure that it is actually eligible. If there isn't anything else involved that's going to cause it to not be eligible, then if they do find that, they're supposed to send that to the court, and then the court is then supposed to seal that record, which means for something to be truly sealed, you have to send it out to all of the agencies that have these records. So this requires a lot of manpower. Right now, the courts don't even have the ability to send out, in Harris County, the courts do not have the ability to send out service on the orders of sealing, on any of the applications that we do for sealing. So we have to do that ourselves. So imagine having to do thousands of these. That's just not possible for the court to do right now. Additionally, the probation department has to go through all of this, and in Harris County we have massive numbers of cases that they have to look through and decide, are they really eligible? The 5 agencies at least that hold these records is HCJPD, the DA's office, DPS, the Harris County Sheriff's Office, the arresting agency, if it's not the Harris County Sheriff's Office, and schools and school districts, as we just discussed, have them as well. Also, DFPS is going to have those if those kids were ever involved in foster care. Now, I mean, to actually just sift through it and decide, who are these schools? What are these schools? Were they in DFPS? It takes a lot of time. So it's a very difficult process. And currently, Harris County has a 20,000 case backlog before they can even address the issue, the cases that are coming in daily. So, I mean, bottom line is it's really not happening in Harris County. And other jurisdictions, we're not really sure. I think smaller ones say that they are, but we've also been told that, for example, we have a case for a dual status youth. We seal records out of county as well. And so we have a dual status youth who picked up quite a few offenses when she was 12 in Lubbock County. And they told us when we looked through and tried to seal that record or seal those records that those had already been sealed. Well, then, of course, we were also handling her case here in Harris County, so we knew from our juvenile probation department that those records had not been sealed. So how do you really know? It's interesting. Even if it were happening as it should, it's highly unlikely that the process would result in a thorough sealing of these records. It's just not possible to, I think, be sure that whatever agency, whether it's the Juvenile Probation Department or the courts, are going to be making sure that these records are going to every single agency that has them on each case. You can really only determine that as if you're the lawyer working on the case. And talking to the client and making sure that there isn't something that you're missing. So, as defense attorneys, don't tell your client that these records are going to be automatically sealed without any action on their part, because that's not fair to them. you need to be clear. Section 58-262 requires what juvenile probation departments are required to give to juveniles in writing about the consequences of having a juvenile record and sealing options. But attorneys should be discussing this with their clients as well. And to be accurate, you should definitely be discussing the issues with sealing without an application, or you are not giving your client complete information. So filing an application for sealing records. Right now, you can only be eligible to seal your record either if you're 18 years old or if you're younger than 18 and 2 years have elapsed from the discharge of the case, whichever comes first. It used to be that we were able to seal these immediately for misdemeanors and deferred adjudications. Unfortunately, the most recent legislature changed that, and Jean Woon is going to talk about what we're trying to do now, right? Yes. And just quickly, those records that are not eligible for sealing are determinate sentences, or if you're currently required to register as a sex offender, or if you were you went to TJJD unless you've been discharged. So we are now trying to fix the last bill. And Jean's going to talk about where we are on. Representative Jean Wu is going to talk about where we are now on this process.
Sure. Thank you. I wasn't really planning to come up here, but I'm actually, we're still in the middle of session right now. I had a bill to basically put this back to immediate. That bill got out of the House, but is not going to fly in the Senate. What there is another bill being carried by Representative White, and one by Senator Perry. This is the compromise bill. What it says is that upon dismissal, if it's a not guilty by judge or jury, then the sealing is immediate. Okay, that's returning it to where the law was originally. If it is a deferred, it was a finding. If it's not a finding of not responsible, then the wait is now 1 year. So it's better than where it was before. But this is something that juvenile probation and TJJD was fighting against. That they don't even like it at 1 year. But this is something that they're willing to compromise with. And the House version went off the floor yesterday. On local consent, and the Senate bill is headed off the floor and local consent as well. So I think both bills are identical. So if both bills get passed out of each chamber, it should just automatically go to the governor. And I'm not going to move forward with my bill because it doesn't have legs. I'm sorry. Yes, it'll be lowered to 17. Any child. Okay, let me back up a little bit. Any child, the bill that as I've seen it. Any child that is below 17, you only need to wait 1 year. If you're above 17 at the point the record is made, it'll be at when you turn 18. So if you're 17 years old, you have less time to wait. If you're below 17, you have to wait 1 year. Does that make sense?
So it's either 17 years old, or if you're less than 17, then it's 1 year wait. So, or when you turn 17, whatever comes first. Not ideal where we want, but it's better than nothing. And this is what I can get moving. And my goal for a lot of this stuff is chip away at it every year. Chip away at the session. If this goes through next session, I'll try to come back and see if I can knock it down to 6 months. Shh! Don't tell anyone. I think Miriam. So I actually got into a huge fight with TJJD and the juvenile probation chiefs about this. Their concern is that if a child comes in, does deferred services, does mental health court, does care court, and receives a bunch of services, and then they're discharged. The record is sealed. Something else happens. They come back into care, and juvenile probation can't see those records. And if you're juvenile probation in another county, you don't even know that that child came into care anywhere else. It's a legitimate reason. I think it's rare enough And I say, like, you guys are basically screwing over like 99% of the kids because of the 1%, but I'm not saying I agree with it, but that's their rationale. Say that. I know you said something snarky. I just can't tell what it is. It's not the legislators. I'm telling you. I said this in past CLEs before. Like, the juvenile law and CPS law is one of the least understood areas of the code of any practice area, because there's only like 5 of us out of the 81 members who practice this area. And even in the other like 4 people who practice just a little bit. I'm the only person who's like essentially does this full time. So most of the times what they do is they just listen to their juvenile probation chiefs. This is the whole reason. Every time I see Tom Brooks, I tell him he's personally responsible for raise the age and not passing for 4 sessions. I tell him he's personally responsible for over 100,000 kids having permanent records as adults. So you can tell him that too when you see him, especially since he's retired now. What? I think so, but I think this is something. It's going to take a lot more time. If you have time to write a letter, I want you to write a letter about raise the age.
No. I mean, yes, but we want ceiling too.
Like, ceilings is one of those things where it's low enough, like people don't understand it enough, where I can over time just influence people and just like slowly pull them in the direction I want. It'll just take a little more time. Look, I mean, here's the thing. When I talked to Senator Perry, I told him, like, look, the ceiling bill that you guys did in 17, muy bueno. It's very good. A lot of the stuff is really excellent, except for this one thing. But the one thing on there, that was the compromise. The compromise is like we're going to keep all these agencies from being able to see this stuff, and the compromise is that you won't be able to seal it until you turn 18. This is how the legislature works. Sorry.
But what makes no sense is that
There is a legislature, and nothing makes sense.
for the 2017 amendment, the change in there, it allows either 18 or 2 years past the last application. So if you got it at 12, at 14, then we
Right,
get hidden.
exactly.
That's that argument about bringing it back at 15. No one would see that he got the adjudication before.
Yeah.
You're asking for logical consistency in the legislature.
Thank you.
I can do an update of some of the other items in Lake Harris.
Yes.
The Harris County Bar, Houston Bar Association provide lawyers for risk. I know it's pretty darn expensive to file this.
Yeah, so that's exactly right. So our program, the JCAP program, provides both law students. We run a program teaching law students how to seal these records, and that's how we've sealed so many. And then we work in coordination also with the HBA that provides pro bono attorneys. And we do the training with them to train lawyers how to seal these records. So there's our 2 programs. You can send people to your clients to us, and we will seal them cost free, which. And we'll also train you if you want to learn how to do it, if you want to become a pro bono lawyer to do this work, because there are, as you can see, there's a lot of work out there for these to seal these records. So we want more and more people to be able to do it. Quickly, felony formal adjudications, they can be sealed too. You can apply at 18, just like misdemeanors. Felony adjudications are never eligible for sealing without an application, so the only way that you can ever get these sealed is by application. That's about 50% of our cases. And you can't seal determinate sentences, so you're not dealing with, things that might give you pause about sealing them. But very often, these are the cases that make the most impact on these kids. We're talking about certain types of sexual offenses, aggravated assault. They're really being hindered and impacted by these records. quickly, there's never a filing fee there's in the law, it states that you cannot charge a fee. The courts cannot charge a fee for filing these sealing applications. We have actually encountered other counties where they are charging, but then when presented with this law, they decide, oh, well, wait a minute, no, we're actually not. So be aware also that we've heard stories now of many people going to people who claim to be sealing juvenile records for them, and they're charging for filing fees that don't exist. So it's really important that people be educated about what they do have to pay for and what they don't have to pay for, because it's just a terrible thing, I think, that people are making these kinds of claims to be able to seal records and then charging people for things that are not even actually fees. Expunctions and non-disclosures, those adult records, thank you. Those will have, like, JP and municipal courts can have filing fees, as well as the district courts for adult expunctions and non-disclosures. You can just refer to this to find out what is required in the application that you file, because I'm starting to run out of time. This is the list of agencies that you need to include in the application of order, and I've already discussed that. So what happens after these agencies receive the order to seal? They are then, at that point, 60 days after they have received it, they are required to seal all their records and send everything back to the court and digitally expunge what they have. And they are required to tell anybody who asks about any kind of record about an individual that no such record exists. That's what they are required to do. And a person whose records has been sealed is legally allowed to move forward as if that offense never occurred, that they were never involved in any type of juvenile or criminal offense. Legally, they can deny that ever happened. As I said, with regard to federal records, it's a little bit different because they have different access, but on a state level, you're allowed to say no such thing exists and not put it down on any kind of application asking for criminal offenses. Again, cost-free sealing program, and additionally, we do want to train more lawyers, so we have templates. The only thing that we'll give you all of we have like a massive list now of how to serve all of these different police departments and school districts, and we have everything is being updated constantly as we work on them, and we will give you all that. All you have to do is come to one of the HBA trainings so that we can be sure that you actually know what you're doing and you do it correctly. And that's the end.
Let's give 100% attention to our last two speakers, because this is a really, really important topic on collateral consequences.
Ellen Marrus is the Royce Till Professor of you can go around. Is the Royce Till Professor of Law at the University of Houston Law Center and the founder and director of the Center for Children, Law, and Policy. She's also the co-director of the Southwest Regional Juvenile Defender Center and has been since its inception. She came to the University of Houston Law Center in 1995 after serving as a juvenile public defender in California. Professor Marrus has directed the clinical programs at UH Law Center and currently teaches juvenile law, children and the law, street law, which I'm interested to know what that is, professional responsibility, and practice-related courses. Professor Marrus' scholarship focuses on juvenile law, representing children in court, and the intersection of juvenile justice with race and gender. She has written a case book entitled Children in Juvenile Justice, with a third edition forthcoming, and has written chapters in and edited 2 books, Children's Sexuality in the Law and Rights, Race, and Reform, 50 Years of Child Advocacy in the Juvenile Justice System. She's also published numerous articles in national law reviews and international journals. Professor Marrus is a certified juvenile training immersion program trainer and has conducted JTIP trainings around the country. She's also presented at various national and international conferences on children in conflict with the law, children's rights, and professionalism. Professor Marrus is joined today by Gavriella Roisman. Gavriella Roisman is a part-time 3L at the University of Houston Law Center and an Irene Merker Rosenberg Scholar. She is a returning student with a background in education. Ms. Roisman has worked in multiple community organizations within Houston and Los Angeles with a focus on engagement and outreach. At UH Law Center, she was awarded the Marvin D. Nathan Fellowship at the Anti-Defamation League and now sits on that board. Ms. Roisman is currently a street law instructor at the High School for Law and Justice and also teaches current event-based law classes as well as coaching Model UN at a local private school. Please welcome Professor Marrus and Ms. Roisman.
So, that light is terrible. So, just very quickly, street law, since it was mentioned twice, is a course where the law students go into the high schools and teach students about the law. And it culminates in a mock trial during the spring semester, which we just had recently. So we're always looking for lawyers to judge the mock trial, and it would be very nice if all of you could do that, because we always need a lot of lawyers. And it's amazing seeing the kids do it. And they learn a lot about their rights and responsibilities during the course for the whole year. That's all I'm going to say about that. Okay. So first of all, what are collateral consequences? You know that. It's what happens after there's either an adjudication or a conviction. Many of you probably work a lot around this, particularly for adult offenders, but it's also really important for youth because they're going to suffer some of these things continuously. There's a couple of things that I want you to remember as we're talking about this. And one is that if your client moves out of the state of Texas, some of those collateral consequences could be different. And you may not know that's going to happen. So it's something you have to talk to your client about, that's a possibility. Just like if somebody is coming from another state to Texas, some of those collateral consequences can change for them. And I often get a lot of calls from attorneys telling me, my kid's moving to Texas. What's going to happen with the sex offender register? That's a big one because it's very different from state to state. In addition, some of the collateral consequences change. And they could be one way on June 1st, and then it can change on July 1st. So you have to keep checking what's going on. And this is particularly true with the college applications, with the military, employment. These are things that change continuously. The other part of this problem is that even though the law or a rule from an organization might state one thing and not consider juvenile adjudications, the way it's implemented is oftentimes very different. So again, it's something that your clients have to be aware of. Obviously, it's important to talk to your client about collateral consequences. And it's important to do this all the time, more than once. You're going to want to talk to a client about it when they're considering whether they're going to go to trial or take a plea, because those collateral consequences can make a difference in what they might want to do. You're also going to talk to them during the process of the trial or while they're taking the plea. You're going to talk to them again about it after disposition. You're going to talk to them about it continuously as they navigate the system because they're not going to hear everything the first time. And it's complicated for you. It's even more complicated for them. One of the things that you can find on the center's website, and I have some here, is a card that you can give your client also that outlines the different collateral consequences, the issues that can come up for them. It doesn't talk specifically about sealing, although there is a little bit about it, but it doesn't tell them how to do it or how to find help to do it. It's mostly just what these consequences are, and you want to look at sealing your record. So I have some here if people want to pick up later, but you can also download it from our website and print out copies also.
The next question is, when do records actually begin for somebody within the juvenile system? And a juvenile record can begin at as early as detainment, but the police records begin as soon as that child is in holding. It can include things as peripheral as the photographs and fingerprints, and no charges are actually necessary for those police records to begin. And as Ms. Dow explained, the new statute requires different times for those juvenile records to either be sealed or destroyed. So if a hearing doesn't occur by the second workday, the records are supposed to be destroyed. If there's an agreement without a hearing, like for first offenders, those records are supposed to be destroyed within 90 days of a successful completion. But as we know, because of both the backlog and compliance, police officers are often non-compliant with the new statutes. And as an advocate, it is critical that you have to follow up and make sure that those records are sealed and destroyed.
So we're going to look at several areas, and one of those is education. And we're going to try and go over some things quicker than others, just because some things have already been mentioned. But one of the concerns with education is also what happens on the primary and secondary level, because it's not just a matter of college applications, but also what happens at that lower level.
Okay, so law enforcement has to inform schools if a child was arrested for any felonies and some misdemeanors. And those misdemeanors can include possession of unlawful weapons, possession of a controlled substance, assault, unlawful restraint, deadly conduct, indecent exposure, and terroristic threats. And what happens when those get reported to the school is that principals can notify teachers of these offenses. And then further, schools can remove those children from their regular classes and place them into alternative programs, especially if a child was found guilty of a felony or received a deferred prosecution for a felony, or even if a principal simply suspects that a child committed a felony. And the consequences for these children can truly be grave, because they don't only affect their legal and professional futures, it also has to do with the child's social, emotional, psychological, and educational futures.
In addition, although the numbers in Harris County have gone down as far as referrals to the alternative schools, they're still happening. And that's still something that will have a detrimental effect for your client that you want to make sure that you talk to them about. So the Common App was talked about a little bit by Ms. Dow, but it's a problem, because right now it says on the Common App that a youth has to disclose an adjudicated delinquency. In the very beginning of the Common App, and college applications in general, young people did not have to say that. And attorneys were very comfortable saying to their clients, well, that was a juvenile adjudication. It's not a conviction. You weren't arrested. You don't have to report that. And one of the reasons the application was changed was because there was a young woman who committed a serious felony, got her GED while she was in a juvenile facility, and got out and applied to Harvard. She did very well on the SAT. She had her GED and did well, and they accepted her. On her application, she never said anything about her juvenile record. And Harvard found out. She had been there for about a year, maybe a year and a half, had good grades, was doing well, no further problems. They kicked her out. And they said that she lied on the application, which she did not, because there was no criminal conviction. It went to court. There was a long battle about it. Harvard had to take her back. But that put a dent on her education, and it put Harvard to the position where they didn't want that to happen again. So Common App put that in for a long time. The National Juvenile Defender Center has been working with the Common App folks to get that out. And they did it one time for a year. They took it out, and you didn't have to report juvenile matters. Then they put it back again. And now they're supposed to have it out again, and we just looked on their website, and they say that actually juveniles are supposed to report on their website that juvenile adjudication. So it really is a problem for kids who want to go on to college, and there are plenty. who make a foolish mistake and still can't do that.
And another part is some things we're going to point out where the juvenile adjudication will actually affect the future. And then there might also be questions where it actually doesn't affect with some of the things. So especially for college and trade schools, when students are applying for student loans and for FAFSA, it is important to point out that a juvenile adjudication does not affect a student's ability to receive a loan. However, FAFSA will ask about drug-related convictions that occurred while receiving federal student loans. But beforehand, those juvenile adjudications actually won't impact a child's ability to receive funding to go to school.
However, some schools won't give the child financial aid if they have. So there was a young man who, again, had some problems, had a juvenile adjudication, applied to a historical black college, was accepted, and when he got there was told he could not get financial aid. After that, he went to the University of Maryland. He did get financial aid from them. He succeeded, graduated, actually went to Yale Law School, graduated, took the bar, and then was denied admission to the bar because of that juvenile felony. So it still has major repercussions all the way down the line. He eventually did get, by the way, admitted to the bar in Connecticut, and it was the state bar allowed him to practice law, which was a good thing since he had been hired by the district attorney's office to work with.
So next we're going to talk briefly about how juvenile record can affect employment. Obviously, if they're asking for a conviction, we can't repeat this enough. A conviction is different than adjudication. You can answer no to the conviction, especially if the record's been sealed. But for some jobs, a juvenile adjudication can stop somebody from becoming any sort of number of registered, licensed, or certified professions. That can include, as we learned, law enforcement, obviously, nursing, teaching, accounting, law, electricians, professional trades, because a juvenile delinquency adjudication can demonstrate what they consider poor character on applications for licenses and for certifications.
And even when the record is sealed, that doesn't necessarily mean it's just going to open up the door, because the police department still will not hire somebody who has that. And they know, even that the record is sealed, they know that, right? They don't know anything else about it. Yes, they do, because they've been denied.
Right. Which brings us to the military. Which is that a juvenile adjudication can hurt somebody's chances of joining the military. And again, this is true even when the case has been sealed or expunged. The military has the right to ask to see copies of important documents related to those adjudications. And as an advocate, you want to make sure during this process, like we talked about, where you always want to speak to your clients about the effects of sealing records and the consequences, that you obtain copies of the adjudication before the record's sealed if your client might at some point be interested in joining the military. There are certain offenses, drugs, sex offenses, domestic violence, and all felony adjudications might require special permission to enlist, but the military can see records regardless of whether they've been sealed or not.
Right. They see that the person had interaction with the police and with the courts. They don't know what the charge was. They don't know what the outcome was. So if something was changed from taking into custody of a felony and that was changed to a misdemeanor, they don't know that. They just know that the youth was taken into custody for a felony, which actually has more of a problem for the youth.
Out of curiosity, I've seen military officers going up to clerk's offices. Are they getting the kids to agree to allow them into the records when they do that?
That's a good question. I would hope so, and I would hope that they are then able to see the whole record, because that's what stops them from allowing the youth to come in. Even if they want to, they can't do it if they can't see the whole record. So that could be a plus. In some states, even the attorney has to destroy the record when the records are sealed. In Texas, you don't have to. But what happens if your client had an adjudication in Arizona? They'll never be able to get that record unless they have it themselves. That attorney has to destroy it when the record is sealed, which becomes a major problem. If Texas changes the law and you have to destroy those records as the juvenile attorney, you wouldn't have them to give to the youth either. So you want to make sure that you keep a copy, that you stress to the client how important it is to keep copies. And we know kids are not going to. So it's really important to try to stress that and also keep your records for a longer period maybe than you might have thought to.
Next, we're going to touch on how a juvenile record affects the sex offender registry. I'm going to put, this is a lot of words on a slide, so we're going to sort of put the parameters up here. What's important to know is that Texas is unique. Not every state requires a juvenile sex offense to require the juvenile to register for the sex registry. We do, which also, as Professor Marrus pointed out, means that if a juvenile sex offense moves from Arizona to Texas or Nebraska to Texas, it would mean that they might have to register here, even if they didn't have to register in a previous state. The one concession that Texas might have made is that this private registry, sex offenders have to register not only their names, but also all of sort of their physical information so that they can be identified. Children do not have to give those identifying markers, but there is a sex registry in which they have to register. And again, that's pretty unique to Texas. And it's important for your clients to know that they will be part of a sex registry for 10 years at least.
So how can juvenile records affect public benefits? That also can become a problem. Section 8 housing, the family can be put out, particularly if the child has been taken into custody or adjudicated on a drug charge or a violent matter. Gun-related matters would be another one. And even if there hasn't been the hearing, the family can be put out. And this puts a major problem for the youth and for the family, because when the youth is trying to get home, right, that makes the parents feel like, I can't take my son home or my daughter home, because if I do that, then the whole family has no place to live. So how am I going to balance that? And that becomes major problems also. Also, the sex offender registry is another one where that becomes a problem for them. Medicaid also stops when a child is confined or in detention. It becomes part of the state rather than the family. So again, if that child's released and they don't have the records changed in enough time, that can also be a problem. Sometimes some of the supplemental income that the family might get, like SSI, also will stop. And again, that can be a problem because your expenses don't stop and you want your child to come home, but you don't have that money anymore and you lose the home in the process.
Ms. Cody comprehensively went over how a juvenile record can affect immigration, so we're just going over this a little briefly. For somebody with a legal status in the country, certain offenses can make the legal status channels even more difficult. Those offenses include things like drug trafficking, drug abuse or addiction, violation of a protection order, prostitution, and sexual assault. If you have an undocumented status client, even a simple arrest can cause, significant issues with an immigration status. But I think critically what we wanted to point out is that it's important to understand, number one, the immigration status of your client, and that
and of the family. Because you want to be able to work with the family, you want to be able to work with the parents, and that can be a problem that will stop them from coming to court. That might stop them from being willing to be involved and helping their child in that process because they're afraid of deportation. So you have to be aware of the family situation at the same time.
And there are mitigating circumstances that can provide the special immigrant juvenile status, things like abuse, neglect, abandonment, human trafficking, sex trafficking, victim of a crime. And the Immigrant Legal Resource Center's website provides ample information and contacts so that if you had questions about these matters, you could reach out to them, and they're certainly experts who can assist.
And before you either take a plea, recommend to your client to take a plea, or even talk to your client about the collateral consequences of the case, particularly around immigration, suggest that you talk to an immigration attorney that also knows something about juvenile law too. One of the places that you might want to call is the University of Houston Law Center's Immigration Clinic. I know they've helped a lot of attorneys in the past kind of maneuver through this because it's very complicated. Things change continuously, particularly with this administration. And in addition, it depends on sometimes even on the immigration judge. So although they're not supposed to deport a child because of a juvenile adjudication, there are judges that do that.
Back to some things that we talk about, the actual consequences, things that actually a juvenile adjudication will not affect. So a question can come up around civic duties and civic rights. Certainly voting and jury service. A juvenile adjudication does not affect the ability to register to vote, and a juvenile adjudication does not affect the ability to serve on a jury.
It does, however, affect adult sentencing. So that can be affected by the juvenile's record. And if, for example, again, particularly if the child moves from the state of Texas, if they move to California, they move to Florida, under the three strike laws, the juvenile adjudications count towards those strikes. And even if the record was sealed, they're going to get that somehow. I almost guarantee it because we've had lots of problems in California with that. So it's something that you also want to make sure that you're aware of and that your client is, because it can affect their adult sentencing. And sometimes those cases won't be eligible for sealing either.
So this PowerPoint is obviously in the Dropbox. If you guys need more resources, you're interested in more resources, the National Juvenile Defense Center, the Immigrant Legal Resource Center, which we referred to earlier, and then, of course, the Center for Children Law and Policy, where these materials are also posted on their homepage.
And so we have, you can take the card that was passed around and download that, give it to your clients. There's also another little handbook that you can use both for your refreshing your information and also to give it to your client. Just you can print that out. And we're also available just with technical assistance in general. There's one other thing that isn't actually on the website, but you can get it by going to the website and emailing us, which you might also want to give to your clients. It doesn't have to do with collateral consequences, but it's a Know Your Rights card. So it has some general information in the front, but then it has very briefly what they should do if they're stopped by the police. And the first thing it says is to stay calm and do not run away. We don't want kids to get shot in the process, right? But then it's also important for them to know that if they're being questioned, that they can remain silent, that they don't have to say anything, but they have to say that. And if they want a lawyer, they have to say that. And that's all on the card, very simply, very simple terms. And it's something that just even if you're in your church or in the community or anywhere that you might want to have some of these to give out to kids, we'll send you as many as you want. Just let us know, and you can have them.